Hello again, hope you're all doing well, and it finally happened. Every appellate lawyer who deals with vexatious litigants, it's like that song from The Wiz. It is a brand new day because the second district said enough is enough, and they fired a historical shot across the bow that every appeals lawyer should pounce on when dealing with vexatious litigants. Now, this decision is part of the upcoming domestic violence roundup. I've made some improvements, such as a table of contents that summarizes the cases so you can go straight to the decisions that are important to you, and perhaps the biggest addition, an appellate checklist. So, if things go south at trial, you have a roadmap to preserve your best chance for a successful appeal. The drop date is, it's probably gonna be sometime in May. So, subscribe to the Substack, it is free, and you get notified when it's ready. Now, courts all over the country have been struggling with a deluge of lawsuits filed by a small number of people who, well, they sue, they lose, they sue again, and sometimes it just repeats for years or even decades. And with the advent of AI, these pro se filers have been able to ramp up the number of lawsuits flooding the system. Recently, the First District dismissed the appeal of a married plaintiff who used AI, I guess the husband and wife team here, to generate a bunch of fake cases for their brief. And the Third District fined a pro se filer $3,100 for submitting a brief full of appellate slop. Now, dismissals and fines work great if the vexatious litigant owns property or has a paycheck you can garnish, but truth be told, most of these pro se filers use fee waivers, meaning, well, the first two remedies are useless when it comes to stopping their future AI slop lawsuits. And this has forced many states like Florida to enact even stricter vexatious litigant laws, such as forcing the offending party to put up a cash bond or ask permission before they're allowed to clog the docket with more legal slop. Sadly, the ISBA has yet to enact a vexatious litigant statute for Illinois. And the closest we have are really these two cases. ME is a guardianship case that affirmed a trial court's ability to make vexatious litigants ask permission before they can file new motions. And there's also this decision where a prisoner had kept filing frivolous appeals stemming from just one conviction, and the appellate court was like, no more. But again, only for that specific case. Well, that all changed last month with Batista. It is a domestic violence appeal, but really in name only, because it's actually about an unhappy parent who couldn't stop filing non-starter lawsuits. Leading up to that decision, she had filed 7 previous appeals seeking orders of protection in what was clearly an effort to kind of end around her family law case. Now, at first, the appellate court tried to say, hey, these appeals are kind of losers out of the gate, please stop. But she kept on filing. They warned her again. She filed a bunch more, and finally, on her 8th appeal, the court is like, you won't listen, you're judgment proof. So here's what we're going to do. We're going to take the toys away. No more appeals on anything without our permission. Now, for Illinois, this is legally unprecedented. So why is it a Rule 23? Well, I'll get to that in just a moment. But first, let's go to the takeaway. Do our clients have to shoulder 8 loser appeals before we can ask for pre-filing restrictions? I don't think so, because when you read this case carefully, and you should read all my cases carefully, 3 key events transpire that triggered the court's action. First, there was a pattern of frivolous litigation. Second, there was at least one serious admonishment from the appellate court stating this is unacceptable. And 3, and perhaps most importantly, the vexatious litigant ignored those warnings and just kept at it. And I think that's the criteria courts will be looking at if you're seeking pre-filing restrictions. With that said, the reason it's a Rule 23, I think, is because, well, Rule 375 sanctions are always at the court's pleasure, meaning they and they alone determine whether they want to do something or just let it go. Not even a published decision can force their hand. But with that said, even a Rule 23 serves a critical purpose, because although some vexatious litigants will sue the same defendant over and over again, others go after different defendants in different lawsuits. And so the defendants don't know each other, their attorneys are only focused on just that one case, and it can take years or decades before somebody upstairs catches on to what's going on. In the same way, appellate courts don't have the infrastructure to deep dive on every party that files a notice of appeal. But Appellee's counsel, well, now you might be able to do a quick Westlaw search and bring that party's history of filing loser appeals to the court's attention. Now, as I noted before, this case is going to be featured in the upcoming Domestic Violence Roundup. It has about 30 or so decisions from 2025 to present, along with a lot of bonuses, so stock the Substack or this channel for updates when it drops. And before I go, a quick thank you for supporting this channel. Like the practice of law, producing these is always a privilege and never a right. So, we appreciate your support. And as always, until next time, thanks for watching.